at her place. And we have also Jorge Padilla, who is the Senior Managing Director and Head of Compass Lexicor Europe. Welcome all and thanks so much for being here. So we will have a first round of initial positions by the speakers, and then we'll have active discussions involve all of you. So please pay attention and feel free to ask later when we will finish with the presentations. I will give the floor to Justus to start with his slides. Thanks so much for being here.
Yeah, thanks for the very kind introduction. I have been given the opportunity to prepare some slides, so I try to guide you through it. And this is just a sort of disclaimer because in some sense we always talk about the new antitrust concerns and the anti-competitive effects that may emerge due to digitization processes. But first things first, in many markets we have to remember that actually digitization has increased competition in many markets. So for many consumers it's highly beneficial because the markets have expanded and we see more competition in many markets. But we want to talk about antitrust here. So I think there are a few challenges ahead or questions that we haven't asked as seriously maybe before, even though they may have played a role in some minor markets. One question that I can see that is emerging also, even though we don't have a government well, not a new government yet in Germany, I can see that in the coalition talks and also in the what's going on in the ministry, there's already some thought being given whether data resources can turn out to be an essential facility and whether we need to change the law, German competition law in that sense, in order to not only grant potential access to infrastructures and networks, but also to data resources. I think that is an interesting question for competition policy really in the future, because it also follows quite a number of other questions. How do we basically balance the trade-off between privacy on the one hand and competition policy on the other hand, and how can we actually transfer data that is not generated unilaterally by one person, but out of the interaction of more than one person. Coming out of this, there has been a debate emerging whether privacy should play a distinct role in merger control already. So should competition authorities be given an additional task to also enforce privacy? For example, by preventing mergers that would not actually, where we don't see any competitive harm emerging, but probably potential violation of privacy. And I actually think that is not a proper role for competition authorities. Why? I mean, merger control by and large results from the fact that we have to admit that the control of abuse of dominant positions is highly imperfect. Yeah? If that was to be perfect, we wouldn't need merger control. So we think about what are the irreversible damages that can be sort of that emerge. Sort of if I have a merger, can I sort of reverse it? Sort of the potential abusive conduct, and in many cases we say, well, with mergers that may be too difficult to sort of prohibit something that also prevent behavior that we wouldn't see. But I think with privacy it should be much easier. Actually, if firms violate privacy standards, we can also exposed intervene and try to stop this type of behavior. I think the control of privacy or the abuse or the violation of privacy laws should be much more simple in some sense. And then coming more to sort of the core of competition policy, I thought I picked two tiny points, or 2 points I want to talk about. First of all, market definition is a very complicated issue, at least if we talk about markets where we don't see prices in terms of money. And I think the Google shopping case illustrates this particular very well, because as you may know, sort of the Commission, at least in the press statements, is talking about a market for general search. And here already sort of I have not anything to do with the Google case in particular, but I'm highly interested in the case. I think it's very difficult to delineate the market because Typically, users don't have general questions. I mean, they have specific questions like where can I sleep tonight? How's the weather in Hamburg? What's the share price of IBM? Or what's the birthday of Angela Merkel? I don't know what. So they have kind of sort of all kinds of questions. Yeah, and if you think about it, for all of these single questions, yeah, there may be substitutes available. Probably you can ask Google for most of these questions, but you can ask Wikipedia, Internet Movie Database. If you look for persons, you can really look Facebook. You can look at very many pages, especially if you think I want to buy new tune shoes, new sports shoes or something. You can obviously look at Amazon. And here that is the most critical question. I think, where do people really start their search if they want to shop for something? And my impression here is, but Sven can correct me obviously later, that the Commission is focusing a lot on technical aspects when delineating the market. Do they sort of provide the same service from a technical point of view? And not so much what would consumers do. And of course, I can see why the Commission is doing it, because we don't see any price movements on that side of the market. So we cannot really have a typical snip test analysis, because, as we would have done in other markets, where we would say, okay, well, how do people substitute? In some sense, we have a sort of similar questions in grocery retailing, where we always ask, yeah, there's a general supermarket, yeah, and does it compete with drugstores with discount and so on, who have limited offerings? So in the same sense, we can say Google is sort of the large supermarket who has everything. Yeah, but there are these many small search engines like the drugstores, the discount, who have limited offers. Yeah, and in supermarkets, the good thing is they have price movements. Yeah, so we can come to some sort of market delineation and see how consumers switch their behavior. Here, unfortunately, we can't really see it because consumers don't switch because there are no price movements. And even so, I know there are theoretical contributions by Lapofili, Strucki, and others who say, okay, then we can just take sort of implicit hedonic prices like the quality and so on. But I think in practical terms, it's almost impossible to say what's a 5% degradation of quality, or what's a 5% 5% more sort of being 5% more intrusive into your privacy. I think that is something that you cannot really measure. So while theory can solve the problem, I think in practice we can't solve the problem. So we are sort of left with much more uncertainty, and market definition is inherently uncertain, of course, all the time. But here we are even much more uncertain because we don't have the price movement. So I don't envy the Commission, I must say, in getting that sorted. But I also see that we have this extreme sort of uncertainty about what's the correct market. And then, of course, the entire theory of harm depends on market definition, as in all other cases. I think I sort of, given that I have 10 minutes, I think I may sort of not talk about the Google case, and I think you talk about Google Shopping short as well, so maybe we can discuss this later, but I just wanted to point out how difficult this market definition is. I think another sort of issue that is maybe not as often discussed, because it's not only a digital markets theme, is vertical restraints in e-commerce. But that is one sort of my, let's say, being an observer of especially competition policy in Germany, one of the gravest concerns that I have, that is there some sort of, I would say, over-enforcement by the Federal Cartel Office with respect to vertical restraints, especially with what's called dual pricing, price discrimination between online and offline sales, not to end consumers, but on the B2B level. As you may know, sort of the Federal Cartel Office had a number of cases, Lego being one of the latest, which makes it very, very difficult for manufacturers to grant special rebates for offline sales. And of course, I think there are a number of plausible theories why manufacturers would want to have an offline presence. Yeah? And unless you have sort of verticalization or vertical integration where they operate their own flagship stores, which may not be an option for all manufacturers at all time. They want to give some incentive to operate not somewhere in the desert, but to have a stationary presence in cities and possibly even nationwide. And this, I think, is a very strict approach to, I think, which has come to an almost complete ban of the discrimination between online offline sales, at least in Germany, is actually not protecting competition, but may even harm competition, because at least if it leads to exit of brick and mortar stores, because then we have a structural change, may have a structural change in the markets. The theoretical explanation, I think, is quite strict forward, and I think there are good reasons why manufacturers would want to, let's say, soften retail competition in order to keep the brick and mortar stores in the market. One reason maybe the broad stationary presence may have a value for manufacturers. The other one that is sort of course, very difficult to empirically distinguish, and we will have the Coty judgment in a not too distant future. The luxury image may depend on the distribution channel. I wouldn't say that's totally implausible from the start. So this will be something that we will see. And actually also, if we sort of prevent this sort of, let's say, vertical restrictions, I think there may be even more difficult to grant rebates or price differentiation between retailers, between manufacturers and retailers. Why is that? Let's imagine there are two areas of Germany, Mecklenburg-Vorpommern, a rather poor area of the country, and Baden-Württemberg, a rather rich area of the country. If somebody wants to have a nationwide presence, he probably has to give the retailer in Mecklenburg-Vorpommern, where demand is lower, somewhat more favorable conditions than somebody who's demanding the product in Baden-Württemberg, a richer area where you have more demand. If, however, there are no restrictions around online sales, he will not be able to do that anymore, because then in the end the guy from Mecklenburg-Vorpommern will ship everything to the entire country and destroy the sort of business. I think there are a number of reasons that could be possible, and I think at the moment we are too strict here, especially with respect to dual pricing. And I look forward to sort of some guidance policy coming out of the sector inquiries about what to do about the enforcement of vertical restraints in this area. I think I leave it here, given that I have been given a short period of time to give my initial thoughts, and we have more time for discussion later.
Thanks so much, Justus, and we can get back to vertical restraints later. I have some questions, but I need to give priority to the other speakers. So let's go now to Oliver. We will upload just in a minute your slides and we start.
Thank you very much. Well, so while this slides are loading, I thought I'd say hello. So I'm Oliver Latham from CRA Competition Practice. I should start by sort of apologising if I've kind of lured you here under false pretenses and you were expecting Christina, but unfortunately she couldn't make it. But this presentation is based on joint work on cases we've done together, and I'll do my best to sort of channel her so that you're not sort of left too shortchanged by the fact she couldn't make it. So there's a huge amount to cover here, issues around digital markets and platforms. So I'm going to try and just talk through a sort of selection of topics of the kind of taxonomy of the theories of harm that come up in the cases we've seen so far, but also a view to what potential cases could be coming down the road, and in particular thinking about the role of data and potentially theories of harm around platforms sort of using their existing dominance to try and, retain or extend control of data generation to sort of foreclose rivals. Before I do that, I thought I wanted to sort of encapsulate what's the kind of trade-off that we're dealing with here. So, platforms, obviously, they're enormous. We're worried generally that they might have sort of systematic barriers to entry as a result of network effects. And we're also worried about this ability to kind of swing market power and presence in one market to kind of extend that market power into adjacent ones. But at the same time, we also have to recognize that these digital platforms are creating huge consumer benefits. They are innovating like crazy, and there are good things coming out of this. So the question is, where do we draw the line? And the starting point there is that we should recognize the value of bringing complements together and the potential for innovation. But we should also recognize that rapid pace of innovation towards these new frontiers doesn't preclude there being a problem. You could still have a situation where incumbents are kind of leveraging their market power, existing market power, to kind of win those races into new markets, and we could get inefficient outcomes through that dimension. And we could also have a situation where these these platforms get so influential that they actually start distorting competition and outcomes, even in markets where they aren't directly present. And I'm going to talk about news as an example of that. So then the question is, is competition the right tool? We know it's cumbersome, we know it takes a long time, but potentially it may still be the best tool we've got. And when should we intervene, and how should we do it? So I think that's ambitious for 12 minutes, but I will do my best. So the three issues I'm going to cover, first of all, is just theories of harm around integrating complements and how we trade off the kind of economic presumption that bringing together complementary products is efficient and a good thing, but also the knowledge that there are theories of harm and there are mechanisms whereby one can get foreclosure effects. And how does one tell the good from the bad? And I'm going to try and use the Android case where I think there is a problem, and the Microsoft LinkedIn case where I don't think there was a problem, as sort of illustrations of how one can potentially do that balancing act. And I should say that I had an interest in both these cases, worked on both these cases. The second issue is the shopping case. I'm going to talk briefly about theories of harm based on kind of allocating traffic, and whether there's a kind of economic mechanism rather than there's a kind of intuitive story about self-favouring and unfairness and equal treatment, but is there a kind of more rigorous economic underpinning for those theories of harm? And then finally, I'll talk about big data. So let's start about the first issue, so integrating products. So we've got this trade-off here, which is that the issue that I think we have is that we need to avoid this situation where the fact that we've got massive complementarities gets us into this situation where we kind of have excessive intervention, where everyone can say, I've got a complementary product, I'm particularly affected by what the dominant firm is doing, and everyone can point to a kind of vague notion of network effects to say that there's a foreclosure risk. And we could end up having this issue that we've got a proliferation of complaints, but not necessarily because there's an increase in foreclosure risk. And we need to be, I think, rigorous in identifying the problematic cases. Now, of course, there are models and mechanisms whereby we can have foreclosure risk and where tying and bundling and bringing complements together can be a problem. So there's, dynamic leveraging stories based on network effects. There's, in the Android case, these stories about how if you're in a two-sided market and you can't price effectively because you can't put your price below zero, that could give you an incentive to kind of hunt for market power in adjacent markets because you can't kind of fully exploit the monopoly you've already got. But I think the kind of main message I want to get across is that we need to be careful and we need to be rigorous in deciding when there's a problem and when there isn't. So how might one do that in practice? I think Microsoft LinkedIn versus Android is quite nice as a case study because they're superficially quite similar cases. You're talking about, in one case, integrating potentially a social network into a dominant OS, and in another situation, you're talking about bundling a search engine with a potentially dominant app store or operating system. So if you were to apply a kind of vague notion of just saying, well, I want equal treatment, you might say that both of these cases deserve the same treatment of having some kind of intervention to kind of break the tie. But I think when you actually dig into this and think of it in terms of anti-competitive foreclosure, then there are empirical screens we can use to try and differentiate between these cases. So one, I think there's a difference in these two cases in terms of how important the dominant firm's kind of home market is as a distribution channel. So I think in the Android case, you're talking about conduct which potentially covers, the vast majority of smartphones, and you're able to get default status for search across almost the entirety of devices. Whereas in Microsoft LinkedIn, you were talking about, a potential change in your distribution channel purely in static devices, whereas we know that the future is in mobile. There's also questions about empirically, we need to be precise about measuring how significantly product integration is actually going to drive consumer behavior. So if we've got, have we got clear evidence that by bringing two products together, you really are going to get consumers to kind of stick with the dominant firm's product, or are people going to be able to mix and match effectively? And I think that there was data that could allow one to differentiate between the two. But I think the fundamental issue is that whenever we're assessing foreclosure risk, really what we need to do is try and trade off the risk of kind of tipping and sort of network effects leading to monopolization versus the extent of efficiency benefits. And personally, my view was in Microsoft LinkedIn, there was a much more compelling efficiency story, and also much more evidence that tipping wasn't going to be a concern, because you had consumers multi-homing across different social networks. You had social networks which were differentiated in some respects, so you would expect that sort of multi-homing and range of alternatives to persist going forward. And I didn't see those characteristics in the Android case. So I think the story here in this category of tech theories of harm is that we do have the tools to tell the difference, and we should use them. So the second category of theories of harm is the sorts of things we have in the shopping case, where we're worried about this idea of using dominance to sort of divert traffic. And I think I want to talk about this briefly because I want to talk about big data, because I think that's the most interesting topic. But I think for me, equal treatment is a remedy, not an abuse. And there are more kind of rigorous economic mechanisms that we should be talking about. So, there is a genuine concern that a platform with market power is going to have an incentive to distort traffic in a way that kind of boosts its advertising business. And I think that's something we should take seriously. And I think people could be foreclosed and consumers could be worse off. But there are important gating questions we need to resolve. How do we determine causality? When do we know that it's the anti-competitive conduct rather than some other factor that's driven the issue, the decline of rivals? How do we take into account efficiencies? And I think finally, and most importantly, where's the threshold? Because any kind of form of advertising on a search engine is going to introduce an inefficiency, a static inefficiency, and a distortion to the results that get shown. But at what point does that go beyond kind of reasonable monetization of your market power towards something that's more worrying? So I think I've got a few minutes left. So now I'd like to talk about data. So I think this is interesting. I think this is the kind of big, growth area in terms of where we're going to start seeing theories of harm in relation to platforms. So the historic way that people have worried about data is this kind of barriers to entry story about, once you get massive and you've got a huge wealth of data, your kind of algorithms are better and no one else can kind of rival you. And I think that really didn't get very far. And I think the reason it didn't is because there was this real danger of kind of treating kind of learning by doing as an abuse, and of saying that you should effectively kind of expropriate past investments. Whereas I think that the future theories of harm around data are going to be somewhat different, in that it's going to be more about using your existing market power to solidify and entrench your control over the data generating process. And I think there's a much more credible story to say that competition policy should get involved. And before I talk about that, I'd just like to, I think it's easy to think that big data is a buzzword and that it's sort of not as big a deal as people think. But I think there are industries where it has had an absolutely profound impact on how things operate. And I think content production, ad-funded media is the best example. And I think just thinking through the mechanism of why this has happened is super interesting. So the history of ad-funded media is effectively that content was the best way to target advertising. If you wanted to sell fishing rods, the best way to do that was to find a fishing magazine and put ads for your fishing rods, because then you could guarantee that people who like fishing would see your ads, and that was efficient. In a data-driven world, that's no longer the case, because if I've got your search history and I can see you've searched for fishing-related stuff in the past, I can target ads at you without any need to actually have relevant content to show alongside them. And that causes an absolutely profound shift in the role of content providers versus intermediaries. And it's having really massive impacts on things like monetizing journalism, for example. So these are real effects which are going on. And then the question is whether there's a role for competition policy within them. So I think there is a genuine story and a concern that if you've got existing market power, you can effectively use that market power to entrench your ability to collect data. So, for example, I mean, I'm going to give you 3 sort of hypotheses of things that might happen and whether potentially competition policy should get involved. So, one, what if you've got an existing platform and you use that to push a product or service that it enhances your ability to collect data and effectively entrenches your market power? Would that be an abuse? So examples of this would be things like Google's accelerated mobile pages or Facebook instant articles, where a kind of precondition of prominent positioning on a platform is that you basically use a format which has got some kind of inbuilt advantage for the dominant firm. Similarly, what if you use your market power to adjust the incentives for complementary providers, which causes them to change their business model in a way that kind of solidifies your existing market power? So, for example, there's a story around potentially platforms wanting to undermine a subscription-based model for news in favor of a more intermediation-based model. Would that be an abuse of market power? And then the final issue is, what if you kind of build in functionality into your existing products that kind of builds in a kind of data asymmetry that means that your products have got better access to data than potential third-party products? Is that something we should be worried about? So I appreciate I'm basically out of time. So I'm just going to say one more minute, which is to say that if one believes that these kinds of data-related problems are issues that competition policy should be dealing with, then it actually opens the door to a really broad range of social issues that are super important from a social welfare perspective that potentially competition policy has a role in solving. And I think fake news would be an example that if we've got a situation where market power leads you as a platform to act in ways that exacerbate the kind of incentives to lead to these kind of malign outcomes, that could potentially be something that we want to police. And I think these sorts of issues are going to be increasingly important as we move forward.
Thank you very much, Oliver. So I think you have set some very important issues on the table related to market definition, which is important to assess dominance, which is important to assess cases related to Article 102 or abuse. Then we shared about e-commerce and vertical restraints, and then the question is whether the new skinnery, as was pointed out by the e-commerce sector inquiry, also requires some innovation in the way to apply the guidelines on vertical restraints and what are the associated concerns. Then we shared about the role of big data and competition and how it is used, and also about this trade-off between benefits and foreclosure risk. Very useful things on the table. So before we go to the discussions, we will go to Jorge to hear his view on this topic.
What I think I'm going to say is relatively polemical. Let me use a disclaimer first. These are my views, not those of Compass Lexicon, my colleagues, or its clients. So platforms do great things. They transform thin markets into thick markets. They facilitate exchange. They reduce search costs. They reduce transaction costs. They benefit from network effects. They increase, therefore, the size of the markets. And facilitate, therefore, exchange. Let me refer to a concrete platform. It doesn't exist, but it could exist tomorrow. Let's call it Econdine. And it puts together lawyers that are looking for economic consultants and economic consultants that want to sell services to lawyers. And let's think that in this world, we're not talking about the relatively concentrated markets that we see. We have lots of lawyers. We have lots of economic consultants. That's a thin market. It's difficult to find the economists that you need for your case. And economists have difficulties reaching out to all those lawyers. But this is Econdine. This is the business model for Econdine. Econdine puts together the economic consultants and the lawyers and facilitate those lawyers to find the right economic consultant for their case. Now, Econdine, in principle, could be competing with other platforms. It's a good idea, but it's not a novel idea. I think that many people could have come with that idea. Some people try. And so you could have some other platforms trying to do that. But we know that there are fundamental economic forces that are likely to lead to Econdine's dominance. Some of these economic forces have to do with economies of scale and scope. Some of these have to do with the fact that there are indirect network effects. The platform where more economic consultants choose to operate will attract lots of lawyers, because lawyers think that they will find the right economic consultant. And if there are lots of lawyers, then economic consultants would want to be in that platform. And that generates snowball effects that lead to increased concentration. In fact, we know, as explained by Oliver before, that there may be circumstances under which the power of those economies of scale and scope and network effects lead the market to tip, so that Econdine becomes, not only enjoys market power, but enjoys a super dominant position, almost a monopoly position. There are other forces, by the way, that can reinforce that tendency towards concentration. To be an effective platform, you have to invest, and you have to invest in what? You have to invest in technology that helps, for example, lawyers rate adequately the economic consultants once they have performed their services. 3 stars for good service, either he smiles, he doesn't smile, she is thoughtful, or do they say what I want or not? And different lawyers may actually have different preferences. Somebody may want a good consultant, some of them may want just people that tell them yes to everything that they have in mind. And you need those technologies in order to be able to rate them adequately. And by the way, you could have double rating systems in which the economists also rate the lawyers, and because that may help third parties understand which lawyer should be selected for this particular case. And those are significant investments. Those are investments that involve sunk costs, endogenous sunk costs, because they help to differentiate firms. And again, because of that, you may have lots of concentration. And I think that we would say, is monopoly inevitable? No, I think that, again, Oliver explained before, there may be circumstances where monopoly is not impossible. So, for example, we know that if, for example, lawyers multi-home, that they use Econdine, but they use whatever competitor, Greek logic, in honor to our moderator today, another platform out there. If they multi-home, that may prevent tipping. Okay, that may prevent tipping. Economists feel that then they need to be operating in both platforms. If the platforms are differentiated along one or another dimension, that may also explain why the market doesn't concentrate. But of course, Econdine is clever, and they realize that they face those potential limitations to their market power. Multi-homing may be one reason why they are not able to entrench their market power. Product differentiation as well. And they will think about ways to counter that. After all, their duty is to the shareholders, it's not to society. Do not evil is a nice, do not do harm, do not be evil is a nice slogan, but ultimately you owe your responsibility. You have a fiduciary responsibility vis-a-vis your shareholders. So you have to be creative. What can you do? I'm not going to tell you all the horrible things that they can do, but I can tell you one thing that platforms are doing, which is that they're vertically integrating. So one of the things that you could decide is actually, I'm going to create my own economic consulting firm. I'm going to create an economic consulting firm with which to compete with the other economic consulting firms. Now, you say, I said that this is what people are doing. I mean, the Google case is about vertical integration in a sense. It's, moving into vertical search. You have heard, I'm sure, about Amazon white labels or private labels. That's vertical integration. You may have heard about Apple Music. That's vertical integration, and so on and so forth. And I don't want to say that those moves are necessarily anti-competitive. They're not. They could be, welfare increasing. But if you think in terms of the logic that I was playing before, for Econdine, clearly is a way of doing what? Well, if you have an economic consulting firm, and you support that economic consulting firm by giving it precedence, by helping it with its rankings, and so on and so forth, you're going to have an asset that is hard to replicate. An asset that may actually mean that lawyers are less interested in multi-homing, because what they want is to have access to that economic consulting firm that has been helped because of non-neutral display, for example, in Econdine platform. And in fact, it is going to be very hard if that economic consulting firm gets lots of good rankings, and as a result of that gets lots of business and engages in learning by doing, all legitimate, etc., and develops better skills, and poaches people like Oliver and and others, and increases the quality of its product, it's going to be very difficult to replicate for anyone else. And that means that Greek logic, chaired by a super nice guy, very clever and competent, has a problem because it cannot replicate. It doesn't have that vertically integrated economic consulting firm that Econdin has exclusive access to. And that vertical integration, therefore, becomes tragic because it actually entrenches the market power of the platform in a way that cannot be stopped, that cannot be unraveled. Schumpeter, in this world, Schumpeter is dead. Schumpeter has been killed by vertical integration and non-neutral display. And the question is, what do you do then? What do you do? Well, one thing that you could do is to change your policy regarding vertical mergers. Now, big problem because, for example, this vertical integration may not be the result of a merger. It may be organic. But also, even if it was the result of a merger, because what they happened, Econdin had the brilliant idea of buying, for example, one of the consulting firms that are out there, think about one. Is that going to meet the thresholds? Possibly the economic consulting question is not going to be the largest. It's going to be somewhat middle-sized, promising, emerging. It's not going to meet the thresholds. The competition authorities, then you are not going to see it. So when it happens, when you realize that something odd has happened, it would be way later. So vertical mergers are not going to help us. Can we prohibit vertical integration? Doesn't seem that we have the tools to do that. So what can we do? Well, at least I think that we have to, or we may want to, ensure neutral display. Ensure that, to some extent, Econdin's ability to prop its own vertically integrated arm, its own vertically integrated consulting firm are limited. Now, can we do that with competition policy? That's where I'm going to get more polemical. I have serious doubts. I have serious doubts that competition policy is the right tool to do that. Because, first, it is ex post enforcement. And in some industries, ex post is too late. So I'm concerned about timing. Secondly, I'm concerned about how are we going to distinguish, pro-competitive and anti-competitive effects, efficiency justifications against foreclosure arguments, precisely as Oliver mentioned before. And Article 102 is quasi-criminal. I'm not advocating for sanctions or fines imposed on Econdin. I may want, therefore, to regulate. And that's where I think that what I'm saying is rather polemical. It may be that we need to regulate. We may need to regulate neutrality. And the same way that we have endless discussions about net neutrality in telecoms, maybe we have to have discussions about neutrality in platforms, platform neutrality. Of course, we will make some type 1 errors, no doubt. But the question is whether the type 1 errors are bearable given that the type 2 errors are also likely. Now remember, some of these platforms are going to relate many, many different sides, not just economic consultants and lawyers. They're going to relate the guy that, bakeries with consumers, cinemas with consumers. You're going to wake up in the morning and you're going to say, okay, book me a taxi, make sure that I have a hairdresser at 12, and then, make sure that I have another taxi, and please book me a plane. And that platform, with a very nice voice, will say yes, and will approach whoever on the other side they think that is the best one. Question to worry is whether the best one is not the best one, but is the vertically integrated one. And that would mean that concentration in the online world will spill over to the offline world, and that's something that I don't think that we can afford. So that's why I say that the type 2 errors are likely to be high. They're likely to be, likely, probably, probabilistically, significant. And that's why I'm thinking, or I'm suggesting, and I hope that, this is going to be something that you will be interested in discussing. I'm suggesting that perhaps we should start thinking about regulating platforms, and in particular platform neutrality. Thank you.
Thanks so much, Jorge. So it's an issue of regulation of digital platforms and not only competition policy. I would be interested to hear your views, but before that, Sven, what are your thoughts?
Yes, okay, I'm on. I have to start out with the usual disclaimer that I'm speaking on my own behalf and not necessarily representing the views of the Commission. The title for this for the session is quite broad, and I didn't really know where it was going to go, and George has also asked some big questions, so I'm actually stepping a little bit back and looking at some little bit bigger issues than at least the first two presentations were about. So antitrust enforcement in digital markets seems to have sort of turned into a bit of a minefield for competition authority. On the one hand, you have those who argue that competition authorities should be extremely careful about intervening because these are really fast-moving markets. We like to get things wrong, and even if we do get it right, we will have been fighting the last war instead of the one that's going on right now. And on the other hand, we have competition authorities being accused of being too timid, too slow, and therefore letting these digital giants off the hook too easily. And there are even calls for splitting up these giants, not only in Europe, but also increasingly in the US. And in the US, these calls are often made by people who, in more general terms, really take issues with what has been going on in the last 30, 40 years in antitrust. They're saying we should go back to pre-Chicago roots, before the Chicago school started influencing what was happening in courtrooms, like over the last, like 30, 40 years ago, probably the switch took place. And of course, one of the things that I pointed to is this astonishing growth of these internet giants. And if you look at it, Amazon was founded in 94, right? And Google in 98, Facebook in 2004, and if you then add the two old ones, which is Microsoft founded in 75 and Apple in 76, then we have, as I think who said it, it's the 5 most valuable companies in the world, right? So this is going very quickly, and this probably adds also into the arguments of what could be sort of the new antitrust populists who are arguing, as I said, who are arguing for a broader view of antitrust goals. That has been the norm these last 30, 40 years. It fits into the US debate also coming here about to what extent does increased concentration, has that been a factor in the increased equality that we're witnessing? And even in Europe, you see some voices, or hear some voices that you perhaps wouldn't expect, also saying antitrust should be more aggressive. The Economist have been several articles, Financial Times, you can hardly every week there's an article saying we have to be tougher in these areas, right? And I've been working now for 20 years in competition policy in the Commission, and I frankly cannot recall another period where we so consistently have seen antitrust issues staying in the headlines for such a long period of time. Carl Shapiro starts out a recent paper that will be published very soon. He says, antitrust is sexy again. Where does that take us? And that is a good question. Where does it take me, and more importantly, the Commission? And now I'm going to say, when I actually think the Commission is fairly reasonably in the middle of this debate. I was going to say comfortably in the middle, but I'm not sure comfortable is the right word, right, in this debate. So let me explain what I think. First, I'll say why I think those who are saying we should stay away from competition, from the digital markets are wrong. Typically, you hear sort of catchwords like competition is only one click away, competition for eyeballs, etc. And the idea seems to be there are all these fantastic new competitors springing up from the ground all the time, challenging everything, and the GAFAs are encroaching on these others' territory, just waiting to take the final blow. And I don't ascribe to this sort of rather Panglossian view of digital markets. And I think, was it you who said also, somebody has said, I mean, it seems that stock markets don't ascribe to it either, right? Because if they really were constantly in danger of having their position taken away by new entrants, why would they have so amazing stock markets valuations? Right? You have Amazon, hardly has made a bit of profits, but not that much. If it really was about, I mean, it can only have that valuation if people think they're going to be making a lot of money for a long period of time, right? So if there really was all this going on here, and they were just about to be taken away the market position in a week or two, then they would not have these evaluations. So don't get me wrong, I'm not saying that this means that I don't acknowledge all the benefits that they are giving. They are bringing fantastic benefits. I'm not saying that they've gotten there because they're necessarily doing bad things. I'm only saying I think it is a valid thing for us to have an eye on what's going on in these markets. There must be some barriers to entry. That means that they have solid positions. I'm not going to say they're all dominant positions, but these solid positions, that means that it's valid for us to have a look at it. Then what about the argument from the other side that we are too slow and too timid? Then we get into, well, I mean, I'm actually not sure we're that slow. Of course, we can all think of a case that most people will think took a long time, but there's also my favorite case shows the other thing, which is the Amazon MFN case in ebooks, which we opened in June 2015, and in May this year we had a formal commitment decision, which basically eliminated all the clauses. So it can be done quickly, and sometimes from the outside, especially some of those who criticize a lot, it seems that they don't necessarily know how things work, right? I mean, this is hard work, right? A big antitrust case is hard work. It takes a long time, and we have to gather a lot of evidence, and we have to get it from companies that not necessarily are really eager to help us in what we're doing, right? They have their rights, and they use their rights, sometimes in a tough way. It takes time. And it can be as frustrating to us as it apparently also is now to somebody from the outside. But I should say sometimes these critics are also asking us to do things we cannot do, right? I mean, in the US now, the debate seems to be sort of going back to these populist arguments that the size in itself of these companies is a problem, right? And it goes over to they have political influence, and I at least think we should stay away from that. I hope we will stay from that. There are issues that I think competition policy cannot and should not handle, and where there's politicians who have to make up their mind whether they think this is an issue. So what is this reasonable position in the middle? Well, actually, I think if you look at it, we are not doing that many cases. We're taking, it's a few cases. It's not that we have loads and loads of cases. I mean, they make the headlines, but it's not that we're chasing around and whipping up cases all over we have lots of complaints coming to us that we are saying, no, we're not going to do that. And we have a few cases we're doing. We are looking at, I think, situations where we have well-established dominant companies trying to strengthen their dominance, trying to leverage their dominance into other markets. So are we up to the task? Generally, I think we have, as economists, reasonable tools to deal with it. Sometimes it's not completely. Something new comes up, and then you see academic economists are sort of springing on the thing, and 5 years later you have articles analyzing the retail MFNs a situation where you saw there was actually not that much of literature 5 years ago, and now there are lots of very good brains threw themselves into it, and we're getting publications out in journals now that help us. So I think we overall have the tools. There are things. I think we also have to say that perhaps there are things we cannot do, right? As antitrust authorities, competition authorities. You pointed to one thing where perhaps if we want, I'm not saying I agree with you, but if there are certain things where also it's politicians saying I cannot load everything onto competition authorities, of things we will have to have regulation to. And you point to one that you think regulation might be the right answer. So again, I'm not going to say I agree with that, but there are things where we will really be stretching if you wanted to pilot. It seems now that sometimes from some critics, it seems that they think we can deal with everything. I'm not saying now it sort of sounds I'm being Panglossian and saying everything is perfect. There are things I could think of and I'm worried about. They're not necessarily in my area. What I work in antitrust, perhaps more on state aid and merger issues where I could think maps, I could come up with some ideas, but I will leave it for now. I'm not also, let me say, I'm not going to comment because I thought I would comment on what the others said, but it was simply too much. It's in all directions, so then I will take up the rest of the time if I had to get into the details or anything. So,
sure, but we can start the discussion given what people said. So I would suggest to start with this Ecodint platform, and I would like to ask the other speakers if they agree or not. So feel free not to do that if you don't want Svet. But so, do you think it's an issue of regulation, and we should be pro-regulation in this in order to better treat these concerns? Do you agree with these concerns, first of all?
I can understand them. I think, I mean, my impression is every innovation in competition law, a lot of people's reaction is to say, should we really be doing this through this instrument, and maybe we should be regulating instead. So I think it's a kind of standard response whenever there's sort of innovation in that space. But I must admit, I find it a little bit difficult to understand if one believes there is a problem and that regulation is necessary. I think the two can go hand in hand. I think there is a long history of competition enforcement trying to solve a problem, pushing forward, realizing the limits of perhaps how far it can go, and realizing we can ameliorate the problem, but we can't solve it. And then we've built a body of work and an understanding of the problems, which means that we can better inform regulation to come in and kind of finish the job. So, personally, I can certainly imagine that competition policy can't solve the entire problem, but I don't think that's a reason not to try, because I think in that circumstance, we probably end up with a regulatory solution that actually wasn't targeted to the problem and could actually be more harm than good. So I think the two should go hand in hand.
Any comment on that?
To disagree. I think that it's good to use competition policy tools. It's good to try. I think that the big advantage of competition policy vis-a-vis regulation is that it tends to be more disciplined. Eventually, we have to decide whether that, on the basis of our experience, works with sufficient speed and is sufficiently clear-cut. Given all the difficulties that Sven mentioned before, I think that the standards of proof are high. There are difficulties in distinguishing pro-competitive and anti-competitive behavior. And on top of that, antitrust intervention comes with a fine. So we are saying what you are doing is a distortion of the competitive process that hurts consumers. It may be that it hurts consumers without distorting the competitive process, or it may be that, in a sense, it is the natural consequence of the logic of that business. I think that we have seen competition authorities trying sometimes to do things that that competition policy is not particularly suited to do so. Like, for example, determine what is the right level of copyright royalties in intellectual property. Competition authorities all over Europe keep insisting these royalty rates are excessive, but they never say what are the right royalty rates. And that is kind of an endless process. It can only be solved one way, which is through regulation. So I'm not disagreeing with Oliver. I agree. I think that it is worthwhile trying. But I think at some point we have to ask ourselves this difficult question, especially when in an industry that to a large extent it's populated by Panglossians about the virtues of potential competition, etc. We're going to have to ask ourselves the difficult question of whether it is time here also for these wonderful animals that we need to regulate them.
Can I ask? Do you think you could actually define what this? Do you think you could actually define what this regulation would be? Right. Again, there are lots of platforms, and you would have just saying sort of a thinking. You shall not advantage. That's not going to be very practical from. So what would it actually look like in practice?
It's somewhat surprising that you're asking me that question, Sven, because I think that's something that you should have investigated and considered in the Google shopping.
We are doing it in the Google shopping in one case. That's what I'm saying. We know it's difficult, right? But writing sort of a general regulation that covers everything that might go on and which may be under the hood of, then I'm just.
So Georgios, if I may.
Two issues. It is difficult, or it was difficult for you in that particular case, for a reason that actually militates in favor of regulation. And that is because within the tool of 102, you are limited in the sort of remedies that you can impose. I think that you have limitations, legal limitations, as to whether you can go beyond cease and desist and give, and I think that it's going to be interesting whether even the guidance that you are providing in that decision as to the sort of how things should be done in the future, whether that is within your legal powers. And that's a constraint that you wouldn't have with regulation. Secondly, I'm not saying that regulation is one size fits all. I mean, of course, you're not going to regulate two different platforms in exactly different ways. I think that there is going to be a common principle on what I have in mind, and that's neutrality in display. The same way that net neutrality won't look like exactly the way that I would implement search neutrality. You will have to reckon and acknowledge the particular characteristics of each of those platforms, and to start with, whether that platform is one that merits regulation or not.
I'm more skeptical, I would say, about the proposal to regulate for platform neutrality. And that's not only because of the, let's say, realities or political economy of regulation as it typically turns out to be in the end, but also because I'm concerned about the sort of effects that they would have on innovation and maybe even on competition, actually. I mean, if I think about, as Sven said, there are many platforms, from Google to like pitchandsale.de, and all types of different platforms that you have. So Amazon, you can think about Amazon Marketplace is clearly a platform. So we can think about what's the dominant search engine for books. I mean, if you ask people, where do you search for books on the internet? I bet that the large majority search for books on Amazon. So you would say, okay, the consequences, Amazon, you cannot favor your own books, your own bookstore anymore in that sense. Since you are a search engine for books, people search for books, and you have a bookstore, you need to offer now all types of different bookstores. So Amazon may say, okay, well, that does not particularly so it's not particularly good for our business. But if we sort of go one step back and think, okay, Amazon was not a platform all the time. So first they were only a bookstore. So then they had the idea, why don't we open up our platform for others? So you don't need to buy the books at the Amazon bookstore. You can also buy them somewhere else. Would I do that ever again? Of course not. I would not ever do that again. Because I know as soon as I invite somebody else to be listed on my platform, I cannot favor myself anymore. The same is true for all these, Alexa and all these devices that you talk to in your household are called. Of course, what's the strong incentive to develop them? Clearly the incentive is that you can favor yourself to some degree. If you can't favor yourself, well, you may say, okay, then why don't they increase the price for those devices? So why don't you follow some other business model? Maybe that works, maybe it doesn't. And in some cases, I agree, there may be grave competition concerns evolving, depending to a large extent to the amount of multi-homing that people either engage in or would engage in if they are not happy with the platform. And in that sense, it may be good to intervene. But then the question is, how do we intervene exactly? Sort of what's the sort of institutional structure that sort of intervention? And here we could probably, I could see some improvement also in competition law enforcement, in fact, but this sort of attacking the gravest abuse cases seems to be preferable than given sort of maybe sort of a different judgment about sort of how that affects innovation in the end, than having a regulator who's obviously operating ex ante and has to approve everything that the platform does.
So there is also this issue of timing, I guess, ex ante versus I try to intervene when the market is in operation and try to correct some behavior ongoing. But so
also a matter of the extent, I think.
Yeah.
Sort of, I mean, you're even in competition, or you're allowed to favor yourself as a dominant platform, as long as it's not sort of going to actually have foreclosure effects. So while with regulation, let's say the standard is much more strict, typically. As we see with net neutrality, I'm not very convinced that net neutrality, as it is implemented now, is, I mean, in many cases, it's clearly harming competition in the market. Because you are not allowed to have sort of, let's say, when the Pokemon Go hype was around last year, O2 or Vodafone or any other company would not have been allowed to say, we offer you 0 rating for Pokemon Go as some sort of competitive sort of offer in the market, because it would have violated net neutrality, clearly. Would that have harmed competition? I don't think so. I think it would have fostered competition.
Any additional insights, comments on that?
No, I was going to make the point actually of net neutrality.
I don't disagree with Justus' intervention. I think that what Justus is saying is this sort of intervention would possibly involve some type 1 errors. And those type 1 errors are going to have to do with innovation. And I think that it would be responsible on my part and not very clever to deny that. I think that those errors are there. I acknowledge them. The debate about net neutrality also talked about the potential downside of net neutrality regulation on innovation, and it's no doubt that it can have effects. I think that it is a delicate balance, however, that of balancing the type 1 errors with the potential type 2 errors. I think that it all depends on in which world we are operating. In net neutrality, we are regulating typically markets that are not monopolized, that are oligopolies, and sometimes even relatively fragmented oligopolies. And yet, we regulate. Some of these platform markets these days are much more concentrated than our telecom markets. And yet, we don't do much. And we are, talking fundamentally about the antitrust policy tool. I have my doubts about the potential of the antitrust policy tool, especially when it is limited to Article 101, 102, and merger control, where you don't have, like in the UK, for example, the possibility of conducting market investigations, or when you don't have tools like the FCC or the FTC have in the US. And what I'm thinking is whether Europe should consider, I'm not advocating for immediate regulation and certainly not for regulation of every decision of the platform, including pricing, et cetera, et cetera. That wouldn't be my objective. But I think that whether Europe should consider whether it should arm itself with a regulatory tool and explore the possibilities of regulating at some point if certain conditions are done, and with the difficulties of defining what neutrality, display neutrality or platform neutrality would mean. We know that things take time in Europe, so I'm not sure that it is a bad idea to consider the possibility that this is something that we may want to do someday and start thinking about the pros and cons of such an intervention.
Thank you. Unless there are any comments on that, I would like to open the floor for questions. Okay, I have 3 hands in a row. We take these 3 questions and we answer collectively. Yeah, please, the gentleman here.
Okay, Georg Clemens from Compass Lexicon. I would have a question for Justus Hauerkap and also to Jorge Padilla. It's about regulation, competition, and maybe even data protection. So these are 3 topics which are important in digital markets. Germany has recently come forward with the idea of setting up a digital agency. Do you think this is the right approach towards tackling the actual challenges we have in digital markets, meaning the convergence of all 3 maybe in one digital agency, or is it still better to have separated authority dealing with these things because it might simply take too much time to find an agreement on who should tackle what?
Let's go to the first 3 questions and then we answer collectively. Yeah.
Thank you. Gregor Verdeau, Vodafone. I agree with Georges that it's an interesting idea to have net neutrality, but since we have been heavily involved in that, I would recommend that we look at the way the laws are made and then implemented. It might learn a thing or 2 about confusion. One question to the whole panel, actually. I'm quite surprised at the discussion that started in the presentation about data monetization and privacy. I sort of very quickly evolved away from that. And it's actually a concern for our industry and I think others, that we face competitors that are not paid with currency, but paid with data. And I'm just wondering what's the state of play from the EU perspective, and I don't know if it's regulation or competition, in terms of taking that into account, knowing that at the end of the day, this is the consumer's data and the owner is not the company.
Thank you.
Hello, Yorgos Malos from NOR. I would like to ask you a question about antitrust policy. It doesn't have to do a lot with economics, but mainly with antitrust policy of DG Comp. Because personally, I'm a bit skeptical vis-a-vis regulation, but on the other side, I can recognize that sometimes antitrust authorities come too late in order to regulate ex post anyway with fines the conduct of the big data giants. Don't you think that maybe a broader practice of commitments decisions would be better option for the Commission in terms of course, better allocation of human resources? Maybe it's better not to take these cases, let's say, to extreme, just to impose a fine after having consumed years of trying to prove that there's something wrong, and then the court might come and say that no, this was not so, and after 7 years the situation might have changed totally, so it's pointless. I think that maybe the commitment decisions would somehow be the best option in order to balance somehow and to see and control the conduct of these companies in the market. Thank you.
Thank you. So let's start with the first question. You want to?
Thanks very much. We had this discussion about the digital agency in Germany. In the end, we didn't end up with the digital agency, but just gave the Bundeskartellamt, the Federal Cartel Office, a few more powers to conduct sector investigations, especially in the digital area that relate to consumer protection more than to competition. And currently, the first of these sector inquiries goes into comparison sites, comparison shopping sites in particular, but also other comparison sites for comparing commercial offers in some sense, and whether they are acting more or less neutral, actually. So that just started. I don't think necessarily that it's good to have to merge all agencies into one. There are advantages sometimes, yeah, and especially and there's maybe different case for different countries. So in, like, say, smaller countries, I can see more of a benefit to collect the expertise because the agencies tend to be smaller all in themselves. But for a large, fairly decent sized country like Germany, I see less of an advantage of collecting all this into one agencies, given that they are already quite big. The two agencies, the Federal Network Agency plus the Federal Cartel Office. Why is this? I think the regulation of networks, which is done in the network part of the Federal Network Agency, is really ex ante regulation of policy, and also the mode. Let's say the general mode in the agencies is markets don't work, we need to regulate. Yeah, the spirit in the competition authority is more markets work. Yeah, we need to leave them alone by and large and selectively intervene. Yeah, so, and I think this is by and large correct, the mode of operation, or the, let's say, culture in these agencies. So if you move them together, I would be afraid that maybe the regulatory authority takes over in some sense, and we start to regulate all the markets. So I'm quite happy with the solution that we have right now, even though I could see some improvements, I must say, because you said the cases are so long. In Europe, can't they be fast? I think if one, for example, could take the, let's say, competition part of the European Commission somewhat little bit out of make it somewhat more independent. I would say I could see some advantages of cases going faster, and I dare to say that if there hadn't been an election of the European Parliament in between and the new Commission, the Google case may have closed somewhat earlier, if not suddenly Günther Oettinger and others developed some understanding of the case. So the political interference, and that we have the College of Commissioners that every now and then intervene, have a feeling that they may need to intervene, may not be the best to expedite these processes. And I think there could be some institutional benefit of making the executive more independent from people who are interested in policy.
Who else want to comment on the questions?
I'm happy to comment on the third question about commitment decisions versus prohibition decisions. I think it's hard to know what the right answer is until you know what was on the table earlier on. I mean, clearly one would prefer quicker intervention when you're talking about potential foreclosure of competitors, because you don't want to write a prohibition decision after everyone's perished. But if there's not a remedy on the table that sort of satisfactorily solves the problem, then I'm not really sure what an authority can do apart from carry on. So it's kind of fact specific, I think. I don't think one can say we should have more commitment decisions without knowing whether they'd be effective or not.
In that respect, let me add that I'm worried about commitment decisions used in a systematic fashion. It seems to me that an agency that ends up doing too many commitment decisions becomes an antitrust agency that does lots of commitment decisions, ends up being a regulator. Okay, and so I think that and because I agree with Justus, I think that we should keep regulation and antitrust separate. There are many reasons, but I think that a concern that I had during a period of time in which the Commission was focusing particularly on Article 9 is that it was that reflected a regulatory mindset more than the sort of mindset that I would expect from an antitrust agency that presumes that market work, does selective interventions, and tries to fundamentally create interventions that are clear-cut and have deterrent effects, so that, again, people can behave without the need of constant monitoring and intervention by the agency.
I think commitment decisions often can be quite good instruments, especially when there are two things. One is if markets are working, as you say, if markets are moving quickly, we can intervene and quicker. But as Oliver said, you need the other side to work as well with it. If it works with us, then there is an extra argument for actually you're able to reach a better solution often with the commitment decision, because that means that they, at one point, they start working with us to find a solution. While if we have to impose a solution ex ante in a situation where the company doesn't really have an interest, then we are perhaps sometimes working a little bit more in the dark, right? So there is actually sometimes you can actually get a better solution because they want to come forward with information that afterwards, if it becomes really antagonistic, it doesn't work as well. So there is, and I think I mentioned the Amazon MFN that went quickly. We were sometimes able to get something put into the commitments that was only starting, hadn't really started working on the market yet. So I thought it was a very good solution in that situation. On the privacy, I think it is, my personal view, it's hard to deal with in antitrust often, right? It's not, I wouldn't exclude it, but I'm not sure. I think these are one of the things where I think probably regulation is a better solution, and I don't really know what's going on there, so I will not venture into that. On the institutional benefit of separating us, I mean, there is also a lot of institutional knowledge in other parts of the Commission which can be quite useful for us, right? So we would lose that. There will be you may think it would be nice to have it, but we would also lose a lot of information we get from people who are really working with markets and working day to day. So there is a cost, as I think. Hope you could recognize that as well.
Thank you. Other questions? Reinhild. Microphone is coming.
Also that there could be imperfections in competition policies. Could you be a bit more explicit of what these imperfections are and how they could actually be improved? So first we're thinking, how should competition policy or antitrust policy be optimally designed such that you would not need regulation to correct it?
Well, the imperfections are, it's not that I refer to imperfections. I think that my word, if it wasn't this competition authorities can intervene successfully in cases where you have well-designed remedies, like if you are tying, don't tie. If you're pricing below cost, don't price below costs. When we get into other sorts of scenarios, when we talk about excessive pricing, for example, and competition authorities don't feel comfortable saying, don't price at that level, price instead at this other level, they're not going to tell you that. When they have to design remedies in markets where the distortion of competition has taken place for a long period of time and conditions of competition have been changed considerably, they face difficulties devising interventions that can restore conditions of competition. They can tell people, cease and desist, stop. They can tell them perhaps something a little bit more, but it's very hard for them to implement the sort of remedies that would restore conditions of competition, because that means unscrambling the eggs to some extent, to start or to devolve the market to the situation where it was before the abuse took place. Because those involve structural remedies and other sorts of interventions which are very hard for a competition agency to undertake, and some competition agencies don't even have the powers. Competition agencies have problems in the context of 102 limitations that are not due to the fact that they are not the most competent people on earth, which is what I believe they are. But I think that limitations such as, can you impose interim measures in an Article 102? Very hard, if not impossible. And not because the court doesn't grant them. It's because if you understand, if you look at the problem, it's very hard to impose those sorts of interim measures when you haven't decided yet whether the conduct at issue is pro-competitive or anti-competitive. There are lots of limitations. Regulatory agencies have other limitations, but they provide a complementary way of addressing these problems. I think that we have to be conscious, however, that there is a tendency in recent years, not only in Europe, but also on other parts of the world, on the other side of the Atlantic, of letting antitrust authorities or asking antitrust authorities to take measures and to take initiatives that actually do not belong to them. And in a sense, to take responsibility for what the legislator, through its regulatory arm, should do. And why? Well, let me tell you, for example, with respect to excessive pricing, which we see in many cases in Europe. It is much easier to, persuade a company to lower prices if you accuse them of being an abuser, than to introduce legislation that says that prices in this sector should be at this level. And therefore, I think that we're asking too much from competition agencies, and we may want to rebalance the usage of the two tools that we have at hand.
Yes, there is a question there, please.
It's Carol Mask speaking. I'm with Microsoft. I would like to make a little bit of a comment about the market valuation as an introduction to a question I have on this regulation proposal. Isn't the market value reflective in particular of market opportunities, which are not necessarily a result of an entrenched market position, but market opportunities which result from innovation and opening new markets as opposed to exploiting existing markets? And I think that's what we are actually seeing in that industry. And that leads to the question, Jorge, about whether there should be, or before we talk about the scope, whether regulation makes actually sense. And your case study, which I like very much, seems very static to me, and is very much focusing on the risk of vertical integration. And aren't you overemphasizing this risk? Because that's largely where the innovation is happening, in particular in these markets. And I'm wondering whether your model that, vertical integration is bad, there is still a user side which at some point won't like a decision being taken for them which is not in their best interest.
So with respect to the stock market valuations, I didn't make that point. I think that I'm going to ask Sven to elaborate on that. I have my own views about that, but I don't think that they're pertinent here. So with respect to the other issue, I don't think I was static. I may have been biased in a sense because I was trying to be provocative. And again, I overplayed the type 2 errors and underplayed the type 1 errors for which I was severely punished by my colleague on the left. But I think that as part of the type 1 errors, Justus was mentioning innovation. And definitely through vertical integration, you can have increased innovation. Vertical integration may have the form of integration. And there may be some other efficiencies associated with vertical integration. Having said so, I still would argue that potentially there are type 2 errors, which are, some of them are static because they could concern the monopolization or the increase of market power in the market that you are integrating into. That is the economic consulting market in that example. But that was not my main concern about type 2 errors. My main concern about type 2 errors is that that was a strategy aimed at eliminating multi-homing and reducing the possibilities of product differentiation, and therefore ultimately, in a dynamic sense, to entrench the market position of Econdine in the market. So my theory of harm was fundamentally dynamic. But again, one would have to decide where the limits are, and this kind of exercise could be conducted in the context of antitrust. If one of the competitors of the vertically integrated consulting firm complains, or ex ante through regulation. And I think that that's what we would have to consider. I am somewhat pessimistic about what antitrust can do, and therefore, before giving up altogether and adopting an unconstrained laissez-faire policy, and considering whether regulation can do better.
Yes, I think my point was a bit, you were hearing these stories that there's so much competition going on, and they're as if they're constantly changing positions and so on. And okay, let's start with Microsoft and the operating system for PC. What is your market share there, and how has that been over the last how many years? It's not that, it doesn't seem like you were sort of being undermined constantly, right? Then we always hear about Yahoo was ahead and Google overtook them. Look, it could happen again tomorrow. That was in 2004, right? And then we hear about MySpace all the time, right? MySpace, it was way ahead, and yeah, but Facebook overtook it in May 2009, and now they're there 8 years later, and it doesn't really seem like there's somebody else who's really taking, and they're making loads of money, and that's, right? So I'm not saying that it may be because of innovation, yes, but I'm just saying it's not, doesn't seem like these companies are constantly in a threat of being overtaken by somebody else giving these high market valuations, right, that they're having. Because if that was really the case, I doubt that people would be paying that much for the shares. So, and that doesn't necessarily mean that they're doing anything bad. I'm just saying, I don't think we should step away from this whole industry because there's all this turmoil going on all the time, and you can never see. That was my point. I was not saying that it necessarily that they have their positions because they've done something bad. They may very well because of innovation. Probably it is, right? But that doesn't mean that we should not still be entitled to at least have a look at what's going on, right? So that was my only point. That was not.
Oliver, do you want to say something?
Well,
because,
I think the only thing I'd like to say there is, I think, just to come back to this point that integration can be pro-competitive and can be efficient, and I do think that's the best argument against regulation, because as soon as you're in a regulatory setting, you have to have some kind of one-size-fits-all approach. You're not going to be able to do that trade-off, and I think there is a risk that you end up with worse answers, and that you end up suppressing innovation. I don't think anyone wants that. But I agree, reasonable people can differ.
Can I actually make one little thing? One thing that worries me a little bit in these markets is that, so contradicting a little bit myself, is there may be new firms coming up with fantastic ideas who could perhaps threaten these, but they're bought up, right? And we can't really, that was one of the things I'm worried about. I mean, mergers probably can't really handle them, right? But you see, couldn't YouTube had grown into somebody who might have challenged somebody? Couldn't WhatsApp, couldn't Instagram, couldn't they have grown in? But now these companies have just so much money, whenever somebody pops up that might challenge them, maybe a few years down the road, and I mean, they probably know better than we do who might challenge them a few years down the road. And they can buy anything that moves, right? Okay, Snapchat said no, but the others didn't. And I mean, if you're 30 years old and they come and put 20 billion on the table, wouldn't you take it, right? So that worries me a little bit, that there's something, it's not really, again, sure, it's an antitrust issue in the sense that it's something that, at least for the moment, merger control is very, because if it is something, then it's sort of potential competition in a very potential way, right? But it's outside our control, and maybe that is to some extent stopping this, what people are saying, this fantastic creative innovation going on, new firms may come and challenge, yes, but if they never arrive at the table to challenge because they've taken off before, then that is a worry, I think.
Thanks, Wenda. There is one last question that I don't want to miss, and then we will conclude.
Thank you. Simon van Dorp, I'm a journalist for PAR. I have a question for Sven. Speaking about regulation, DG Connect is currently working on B2B platform regulation. I was wondering, could any of the issues spoken about today be addressed by the regulation of DG Connect? And are there any issues that arose from the Google case that could be feeding into this regulation?
I have to say, I don't really know. It's just not. It's not really something I'm working closely with, so I don't want to express myself on that one. But it's clear they are looking into. I mean, generally, I think if there were some nice regulatory solutions to also what Jorge, that was why I was challenging him a little bit. Could you write it up for us, please, right? Because I think there were people would be willing to regulate if they could see there was a good solution, right? But I think also sometimes a little bit once you get into the details and start scratching your head, how do you actually write this in a way that works and covers the situation where you want it to work and does not cover a situation where you don't want it to work? Then it gets difficult once you try to get your hand dirty. So I was encouraging Jorge to go down and write a regulation for us. Right?
And then we can have another Bruegel event to discuss a solution. So I think I like the interesting avenue that this discussion moved on regulation, competition. I didn't expect so much to go to that direction, but I found it very interesting. I would like to thank, and please, I invite the audience to thank the speakers for being today with us. Thanks so much. And thanks so much. Thanks so much for being here. Any comments, any feedback on the events, any questions on the topic, feel free to contact us. Thank you so much.